Let's get more reaction on this conversation. We're now joined by UNISA lecturer, that's Mametlwe Sebei. Mr. Sebei, pleasure to have you on the program this afternoon. Now, you've written a legal and independent opinion piece reacting to this particular move to have UNISA under administration. Firstly, give us a few flashpoints of what you've noted in this piece.
Well, let's start with the law, right? One is that I'm saying that the minister's decision is not only completely wrong, but clearly misguided in law, because the minister seemed to be under the impression that his, application for a leave to appeal the judgment handed against him on the 6th of October, that leave has an effect of suspending the operation of that interdict. Now, he's obviously under a wrong impression that the relevant section in this respect is Section 18.1 of the Superior Courts Act, which does have an effect that in the ordinary course of events, ordinary court judgment is effectively suspended by the leave to appeal, or application, for such leave to appeal, pending the finalization of the matter. But what is applicable in this case is actually subsection 2, which is very clear that is different. The different scenario is where you have an interim order granted in the interlocutory application, which has an effect of preserving the status quo pending the finalization of the matter. Now, the order that was granted in favor of UNISA in October 6th, but also the one that was granted before that, I think on 24th of August, was an interim order in the interlocutory application that said the minister cannot proceed to put UNISA under administration until 2 review applications were finalized. That is, the application by the chairperson of the council to set aside decision to appoint the independent assessor, but also another review application by the VC of the university to actually set aside the report of the independent assessor.
I guess it also then begs the question that now that Dr. Blade Nzimande is seeking leave to appeal, how does it then affect the current legal proceedings pertaining to this matter?
He is in contempt of court. Let's be clear about it, right? You are required, or the minister is required to issue a notice to place the university under administration before he does so. He issued that notice, right? He was challenged in court by UNISA, and he made undertaking in August in the face of a clear, loss of that application in court to actually withdraw that particular notice. And he did that, and that was then made a judgment of court. So it therefore means that in terms of Higher Education Act, which requires a notice, there is effectively no notice at the present moment. When then he proceeded in October without a notice, right, to place UNISA under administration effectively, UNISA again went to court, and the court found him to be in contempt or in breach of that earlier judgment. Now, for him again to proceed, he is, becoming a constitutional, or rather a constitutional delinquent who clearly has contempt for courts. And I think that is the matter that UNISA need to raise, because Section 165 of the Constitution is very clear that decisions and orders issued by courts are applicable, and binding on any person, including organs of the state to whom they apply, and those people are expected in law to actually abide by those decisions. And I think the minister in the cabinet, he is required in this case to abide by 2 successive judgments that said he cannot proceed until the 2 review applications are finalized on this matter.
But let's zoom a bit deeper into the legal options that UNISA actually has. I mean, and what are the anticipated outcomes should they proceed with taking legal actions over this decision?
Yes, and I think to the best of my knowledge, they've done that already. I think the matter is in court at the moment, and I've only heard that the matter is proceeding on Monday I mean, it was supposed to be yesterday. I'm not, aware of what was going on there, except that I know that the ministers acted wrongly in law, right? So, and I think, let's go back to the decisions that he has been taking, right? When you look at the Higher Education Act, it is very clear that actually, even in case of appointment of independent assessors, you can only do so when the council has actually failed to correct the circumstances that gave rise to a need to appoint an independent assessor, or, of course, to act on its recommendations. And I think what the Council of University and UNISA, I think, has been arguing, from what I can understand from their papers, is that one, there was ministerial task team report that, of course, identified problems with university, which problems are genuine, right? From poor support for students, financial, mismanagement, all those problems that were identified in the ministerial task team report that was handed over in 2021. University Council immediately began to restructure its management and made significant appointments, and I think from those appointments, it is clear the situation is being turned around. Every single report, from the Council of Higher Education institutional audits to international rankings of the university, but also Department of Higher Education's own reports on in terms of research output, clearly indicate that there is improvement in the teaching, in the student support, as well as the research output. But more than that, university, even in terms of its financial performance, it was rated #1 in the university sector by the publication Top 500, which assessed the top 500 performing companies and corporations in South Africa. And why? It's because the finances of university speak for themselves. You had a situation wherein as we have said before, that the results of the university improved between 2021 from 9 billion to over 16 billion at the present moment. That is indication that the student is being turned around.
So over the years, the challenges at UNISA have been well documented, but like you rightfully say, we've heard from the likes of the SRC president at UNISA, who adds that there's no evidence showing that universities under administration actually perform well. Give us your own observations.
No, that observation is absolutely true. It's a point that actually I've raised in previous discussions on this platform, right? Look at all the institutions that came out of the administration. The most recent one is Fort Hare, where the situation is far worse. And it's very strange that Fort Hare, where there's a state of war existing in that university, literally with, the VC who goes around with bodyguards, and even those bodyguards being shot, and I mean, there is multiple attempts on his life. That is university coming out of the administration. And the minister does not even see the need to place that university again under administration, when even the VC says, my own life is in danger. It is becoming more and more impossible to actually correct this university. Now, so nobody says there are no problems at UNISA. Right. I think that needs to be contextualized, right? We are saying that UNISA, like many public services, suffered, if you like, hijacked by many interests that are a problem across the public service. SAA is an example of that. ESCOM is an example of that. But I think also higher education itself, right? What we are arguing is the fact that in the past 2 years, a trajectory has been pointing to improvement, and every single independent assessment of university has pointed to that, and we have argued that Musia's appointment was not meeting that requirement. He is not independent from the university, as of course is required by Higher Education Act, that requires that says that the assessor must be independent. He is conflicted, and it is very clear when you read his report and the contradictions where he consciously conflate and confuse issues, that he is trying to cover up people that are implicated in mismanagement of UNISA, but also to confuse issues in respect of where the university is headed. Is it overcoming the challenges, or is it getting worse?
So we are in discussion with Mametlwe Sebei, of course, reacting to the decision by the Minister of Higher Education, Dr. Blade Nzimande, to proceed with administration at UNISA. Mametlwe, good to still have you on. Now, let's get more reaction from you now. The court order underscores the interim nature of this decision and also the importance of preserving the status quo. Could you help us understand the significance of this interim order and its connection to the separate applications filed by the Council and VC of UNISA?
That's the reason that I've started with the legal position in respect of interim orders, right? As I said earlier, and I think it's important to underline this fact, you see, there are two review applications that I've already spoken to. The court orders that has been granted, both in August and in October, they are interim court orders in the interlocutory applications. And of course, the Section 18 of the Superior Court is very clear. When it comes to interlocutory applications and, of course, the interim orders that have been granted on that, because they seek to preserve the status quo pending the finalization of the substantial disputes. And what are these substantial disputes? The substantial disputes are whether the decision to appoint the independent assessors met the requirements of the Higher Education Act, the enabling legislation that empowers the minister to act so. Secondly, whether the independent assessor, upon being so appointed by the minister, discharged his responsibility diligently and, of course, was not conflicted, which I think is some of the issues that UNISA has been flagging, right? So, in this case, the section that is applicable clearly says that the minister's appeal does not invalidate the earlier orders that had been granted. And that's the reason I'm saying the minister is clearly in contempt of court. And if it's an honest mistake, he is being misguided in law. And I think his legal advice or legal advisors need to consider their advice on the basis of the facts and, of course, the advice before them.
Now, we've covered a couple of issues in our discussion, including the legal options that UNISA has. But if the Minister, Blade Nzimande, fails to comply with the court orders, UNISA may pursue legal action to hold him in contempt. Now, let's further discuss these legal options that UNISA has. And in this scenario, what potential outcomes could be anticipated from such actions?
He could be fined. I think that's already, for me, the most likely scenario. Because remember, the interdict of I think the 6th, if not the 4th, I think the 6th of October, already was very clear that he was in breach and effectively in contempt of an earlier judgment granted on this matter. That is in August, right? It made clear that his decision to proceed with administration when he had already withdrew his notice in court, and of course court made that undertaking a settlement, an order of court, right? So he was already in contempt, and that's the reason that the court, having taken a dim view of its action, imposed a punitive cost on the minister. So already I think he's in contempt. I think that UNISA must make that application, in my view, and I think in this situation, probably after the outcome and the decision of this court, for me, what needs to be considered is whether really do you have somebody in office of the Ministry of Education who is in flagrant disregard for the rulings of court, and whether should he be declared a constitutional delinquent whose position itself must be put in question.
Well, thank you, Mametlwe Sebei, for shedding a bit more light on the legal intricacies around this particular decision. Of course, he also wrote an independent opinion piece over the matter. He's a lecturer at UNISA.